were to hit it on the end or whirl it around in the air, that might be actually something that would not be obvious and would be subject to a patent potentially if I applied for one. Another one of the requirements is disclosure of the invention. And remember, I said that the word patent means that it's obvious it's available to people. That it's instead of it's patent instead of latent, which would be something underlying that you wouldn't see. But it's patent. It's out for everyone to see. The idea of a patent is that the government allows you to exclude others from practicing it, but in exchange you have to teach the world about what you're doing. And the reason that's important is that a patent has a particular term. In the United States it's 20 years, and after that 20-year period anyone can practice your invention. So you see, if you don't disclose what the invention is, then people wouldn't know how to practice it. So the idea is you say, here's my invention. In 20 years, anyone can use it, but for these 20 years, I get to exclude others, so I get to get the economic gains of it. Now, remember I said that you have to go through an examination process to get a patent. Almost every country requires this, although there are some countries that may have some forms of patents that do not require examination. For instance, China has a form of patent that doesn't require examination. But usually some human being actually has to look at what you write up and say, yes, this is worthy of a patent, or no, it's not. The examiners are people who are trained in the art. So in the United States, if you were to file a patent on, say, a semiconductor chip, the person who would examine it has knowledge in the area of semiconductors. So the people who work in the patent office are usually engineers. And they make sure that your invention is novel and non-obvious so that you actually deserve to get the patent. Now, in the U.S., actually, if a patent issues, that's not the end of the question, because someone can later come to the court and say, this wasn't really non-obvious, this wasn't really new, it didn't really deserve a patent, and therefore I want you to invalidate the patent. And in fact, when people go to enforce patents, almost half of them are invalidated later on. So actually, it can be dangerous to enforce a patent in the United States because of that. The examination process itself, this is a diagram of how it works. You can't really see, but this is like the long path from filing all the way through all this path until you get to an actual issuance of the patent. It's a long process in the United States. It takes about 2 or 3 years for it to happen. And remember I said the term of a patent is 20 years? It starts when you apply. So really at the end it's only about 17 years that you get the patent rights for. Okay. One of the reasons you might be asking yourself, well, why do I care that a United States attorney would come and talk to me about patents, primarily in the United States? Well, this is why you might care. This is a map. These are done actually by a research organization in Britain. They're very interesting, and they do all sorts of maps like this. But this down here is this is a map. A typical map of the world, showing the geographic size of various places. And what they've done here is they've changed it so that you can see the relative size based on patents that are issued. Okay? So if instead of by geography you changed it to the number of patents issued, this is what the world would look like. Okay? As you can see, the United States has very large element of patent issuance, and who knows what this over here is?
Japan.
Japan, correct. See, that little tiny place over there is about as big as the United States in terms of patent issuance. This is China here, and there are more and more patents issuing in China, and then this is Europe here. So there are EU patents, there are patents in individual nations in the EU, and other places as well, but as you can see, patents are usually driven by primarily the amount of business that's going on, and then also the ability to enforce. In other words, having a rule of law, having strong intellectual property protection causes people to file patents. Now, if you think about why that might be a good thing for the world, you might not think it's a good thing for the world, okay? But if you think about why it's a good thing for the world, here is how the theory works. In these places, people have an incentive to file patents because they know the courts will enforce them. And therefore, they file lots of patents. And what that does is it makes these inventions available to the entire world to see, so that the state of technology and the state of engineering improves for the whole world, because you can actually go on the internet, you can look at the Patent and Trademark Office, you can look at any issued patent you want. I think back to about 1979 at this point. You just pull them up on the internet and you can read about those inventions, and you can see the drawings, and you can see the invention described. So that increases the knowledge of the world. But people will only file patents in places where they think they will be enforced. And I'll also tell you that these are issued patents, but if you were to take the amount of money that people get for enforcing patents, in other words, say I have a patent, and I go to the court and I say, you're infringing my patent, and therefore I want some money to be compensated for that. If you drew that map, there would be no point in drawing that map because it would be all the United States. Because you get more redress in the courts for infringement of patents than anywhere else in the world. And that's why you might care about U.S. patents. Because even though you're not in the U.S. right now, say you want to sell a product, you might want to sell a product in the U.S. You might make, say, a software product or some other kind of product that you want to sell in the U.S., you are going to need to be concerned about whether you are infringing patents or not, because if you are, it's possible your goods will never even get into the United States. So it's very important to understand that patent enforcement is very strong in the United States, and it's a very, there's a lot of monetary gain for enforcing patents in the United States. Okay, what kind of things can you get patents on? But this is where we get into some of the controversial aspects of patenting. Now, in the United States, it works a little bit differently from the way it works elsewhere. So I'll explain how it works in the U.S. because that's what I know. But it's different in the EU, it's different in all sorts of different nations, and it's based on how governments are constituted. So in the United States, we have a constitution that gives power to the government. Okay? It states particularly what powers the government has. So in the United States, the way our government works is, unless the Constitution says the government has this power, the government doesn't have the power. In other words, the assumption is government doesn't have power, but the Constitution says we give the national government certain powers, okay? And the right to issue patents and to control patenting is in our Constitution. It's a very important part of our Constitution. In fact, the person who wrote, or arguably wrote, the United States Constitution, which was Thomas Jefferson, he was an inventor, and patents were very important to him. And so patenting is expressly featured in the Constitution of the United States. And so the courts in the United States that interpret the Constitution, they have said that they conclude that anything is patentable unless Congress says otherwise. So Congress makes rules about patenting and laws about patenting, but the courts have said, we think anything is patentable until the Congress actually makes a legislative decision to tell us that it's more or less narrow, because the Constitution gives the federal government the right to issue any patents they want. And for this reason, there has been very little limitation on what you can get a patent on in the United States. Now, you may know, you may have heard that, for instance, software patents, which are a controversial element of patenting, you cannot get a software patent in many places outside the U.S. And one of the reasons for that is that there's a sort of a different scheme about how the government is constituted and how that power